have a dozen people. It's better than 6. It's better than a half dozen, right? Right. I'm excited tonight to see what Paul has to share with us. It's good to have you here. And I don't know, maybe we encouraged people to stay away when we told them it would be recorded. I don't know, then they thought they could just watch it at their leisure. I don't know what happened. All right, well, let's pray. Yeah. Father, thank you for the opportunity to be here. Thank you that you are our God, that you are a faithful God who never fails us. Thank you, Father, that you provide for us more than we could ever want or need. And Father, tonight we're here to learn and to see, Lord, how you would like to guide us to prepare for the things that are coming in the future. We know the most important thing is that our souls are ready to meet you, Lord, and we are ready for that. And so then we want you to show us, Lord, what we should do with our earthly possessions, because we know we want to store up our possessions in heaven and have our treasure there. But Lord, we're excited to learn tonight. And so pray that you would guide Paul as he thinks of different things, and guide us, Lord, with the questions that we would have, so that you can open our eyes and our minds and our hearts to learn how to handle our finances and our other estate issues well. We thank you in the name of Jesus. Amen. So I would just like to read one verse, because I think we want to hear from Paul, and you all probably have loads of questions. My verse is from Proverbs 13, verse 22. You ready for this? Good people leave an inheritance to their grandchildren. I always said, what? What about the children in between? That's what your kids are all going to say. Good people leave an inheritance to their grandchildren, but the sinner's wealth passes to the godly. So there you go. Okay. I don't know for what that's worth. That was from Proverbs, and we're going to let it there because we don't want to stir up anything. So, Paul, we're going to turn it over to you right away and just turn you loose. I don't really have the capability to introduce you because I really don't know you that well. So if you'd like to do something by means of introduction, that's fine to start.
Okay, thank you, Teresa. My name is Paul Schemel. I'm an attorney. I practice in Greencastle, and I practice in both Pennsylvania and in Maryland as well. So I don't know if there are any Mountaineers from West Virginia here. If there are, I can't answer your questions, but for the rest of you, I should be able to. And Teresa, thank you so much for that verse. You know, inheritance is a lot more than our things. In fact, it's much more. You know, one of the things I tell my wife Lucy and I have 6 children. And one of the things when our children are together, and someone beforehand was asking me about that because we recently had a vacation. My kids, some of them live far away, one in Wisconsin, other places. So it's not often we're all together in one place at the same time. But every time we are, my kids always groan a little bit. I say my prayer every night, many prayers, but one prayer I always have is that all of us are together in heaven. What better inheritance is that than to pass on the faith and to be able to pass on the faith to our children? It's up to our children as adults to make the decisions that they make, but it's our duty to pass that on. So that's our great inheritance. Now, just so I get a feel for who lives where, how many of you are Maryland residents? Live here in the old line state. Okay, great. How many are Pennsylvania residents?
And I'll maybe become one, maybe once I retire,
So there's strategic planning between these two states and the Mason-Dixon line that separates us. You know, because in Maryland, by and large, you can sort of skip all the inheritance tax, although there is an inheritance tax here. But Pennsylvania, you don't pay any income tax on retirement income. So, you know, the best planning in the world is to retire in Pennsylvania, but then before you die, you move back to Maryland. So, but anyway, that's sort of in general. So usually when I speak, and I've been practicing for over a quarter century, from that I've had a lot of experience, which has been great, and I've seen this come full circle. So not just helping people with their wills and powers of attorney, but definitely dealt with a lot of families who are dealing with someone who is sick and in the hospital or in a long-term care facility, and definitely with a lot of estates with clients who have passed away. In that cases, I've dealt with their children. So I've sort of seen things and gained what I consider to be wisdom along the line of seeing some of these things play out. So in any sort of a group, I think more than 4 or 5 people, statistically, there's 1 or 2 of you here that maybe your biggest question to me would be, Paul, you know, sometimes my children bicker a little bit, and what can I do to keep them, after I'm gone, from bickering and complaining with each other? And I have the 100% antidote that you can use, and for those of you then who are interested in this, once you learn it, you don't need to hear the rest of the presentation, you can go home. So that is, if you have children that bickering and complain and cannot get along, and you're afraid about what will happen after you pass away, then what you can do is in your will leave everything here to the Northside Mennonite Church. And I guarantee that your children will be 100% unified in claiming to the court that you were crazy when you made that will. Pastor Gary is happy to tell you the address where that can be done. Thanks so much. It's a privilege to be here. Tonight, I do want to talk about some of the specifics of things that we should be thinking about. And this is kind of a piece of the conversation that I have with individuals or couples that come to see me when they're ready to make an estate plan. And so I'll walk you through that. Some of that is going to be practical taxes and those types of consideration, but some is also just things that you should be thinking about with regard to your family. Because as I started out saying, what do we have that we can really pass along? Things are things. And I like to remind people, things are things. We put importance to them. They are important. They're important in making sure to maintain us and to help and support us. But in the end, they're ultimately just things. And what we really have are relationships. Certainly our relationship with Christ, which we want to illustrate and exhibit to our family. And that's what we want to pass on more than anything else. But we want to think and be cognizant of the relationships of those that we leave behind and what positions we put them in and how that interaction might go. So tonight I kind of want to start with where I usually start with clients, which is to talk about not wills and dying, but to talk about living. And those are powers of attorney, what those are, what they do. I want to talk a little bit about Holst and Most, which are documents that you have definitely here in Maryland. You can find them in Pennsylvania as well. Again, these things are about medical treatment. There's some serious things that I think everyone should think about. Then we'll talk about trusts and what trusts are and what kinds of trusts, what they're used for. Some of this information will be useful to some of you, some not, but you might also find it interesting or important as you talk to others around you, that might come up, family situations and whatnot. And then we'll talk about wills, we'll talk a little bit about long-term care planning, and then finally about estates. I handle estates, and I really would like to talk a little bit about the experience of what happens there. So first, with powers of attorney, people often overlook these. People come to my office, they say, well, we want some estate planning or elder law planning, something people usually don't know what the difference is between all these things. And I'll say, well, let's talk a little bit about powers of attorney. Oh, well, I haven't thought too much about a power of attorney. So, well, I don't really need a power of attorney. Well, if you needed a power of attorney, you wouldn't be cognizant and capable of signing one. That's why we talk about them when you are cognizant and capable of signing one. There are two kinds of powers of attorney in both Pennsylvania and Maryland. The first one is financial. A financial power of attorney, I always tell people it's kind of like a spare key. If you go away somewhere on a trip and you give someone else, whether it's your neighbor, whether it's a son or daughter, whomever it might be, a spare key to your home, what does that mean when you hand them the key? When you hand them the key, are you saying, here's my house, it's now yours? No, that's not what you're saying. When you hand them the key, are you saying, here's the key to my house, now you can go live there or have a party there or something like that? No, not at all. The implication is, this is the key to my house. If there's something that you perceive that's wrong, if you hear water running, if there's a light that's left on, if you just want to check on it, your duty is just to make sure that that asset that's important to me, that home, is preserved. That's what a financial power of attorney is, but it's a key to everything financially you own. So someone who has signed a power of attorney, you designate who's going to be your agent. It can be more than one person. It can be people that work together. It can be a person that an alternate, if they're not, the first person is not able to act. Whomever you want, the financial power of attorney gives them the ability to go to the bank and sign checks out of your checkbook. In fact, 98% I would say of what an agent under a power of attorney does is to make sure that your electric bills are paid and things like that if you're not able to handle your bills anymore, or maybe if you have had an accident and now you're in the hospital and you have to go somewhere for rehab for a period of time. They just kind of keep things going so the status quo is maintained. So banking is the number one thing that a power of attorney in Maryland and Pennsylvania allow you to do. But then there's other powers, and we always include everything that both the Maryland or Pennsylvania Power of Attorney Act allows. So it includes things like dealing with trusts. It includes things like accessing your retirement accounts if you have one, if they need to make adjustments to your insurance. For example, if you've become permanently handicapped, maybe you no longer need that automobile, so they don't need the insurance either. Or whatever the case may be. There's some things on there people sometimes ask me about. One of them is, why does the power of attorney have borrow money? When would my power of attorney, my agent, ever borrow money? I can give you two good examples. One example is that you have a hailstorm, damage is done to your roof, and someone needs to fix the roof quickly before it rains again, but the insurance company is not being forthright with paying on the insurance claim. So they might need to borrow money against your home just to fix the roof until the insurance claim can be resolved. Another instance would be something more basic. Your dishwasher goes up and your son or daughter, whomever is your agent or your power of attorney, goes down to Lowe's and they found, well, lo and behold, they have a sale on dishwashers. It's interest-free for a year. That sounds good. I'll pay it off after a year, no problem, pay no interest. That's technically a loan, and if the power of attorney doesn't actually say the ability to borrow money, you can't take advantage of something like that. But those are typically the kinds of things that borrow money would be under a power of attorney. Another thing a power of attorney document should have is the ability to make gifts. Some are limited gifts. If you have a son or daughter as your agent under the power of attorney, they say, I know it's important for mom or dad to give money to church every week. I know it's important at this charity, or every Christmas they always gave this much to nieces and nephews, or whatever the case may be. Unless it's explicitly written in the power of attorney document, the agent can't make any gifts. They can purchase things for you, they can pay your bills, but they can't make gifts. But that ability to keep on some sort of a gifting scheme that you already have, as long as the power of attorney understands that there's enough money there to do that and they know it was important to you, then they can continue that. But also generally power of attorney documents include unlimited gifting, a second kind of gifting. That is where someone might in the future want to do something that is preparing for long-term care, or Medicaid or nursing home type expenses, which we'll talk about a little bit more later. But that authority gives them the ability to do that. So that financial power of attorney is really important. And people always say, now this isn't good until I'm incompetent, right? I tell them, look, the reason we're doing the document now is because if you're incompetent, you can't sign it. If you're incompetent, we could have a hearing in front of a judge to prove that you're incompetent. The purpose of the power of attorney is to give someone that authority now and not wait until you're incompetent, because that's the alternative. And no son or daughter, no niece, nephew, no one wants to bring someone else into the open courtroom only to have to prove in court in front of that individual that they're incompetent. That's why we do powers of attorney. So, who do you designate for this kind of authority? A lot of people select their kids, that's fine. As I said, you can select one, you can select multiple, they could work together, they could work individually. I like to talk through with clients, not just, people will sort of instinctively say, well, my oldest child. I always say, let's talk a little bit about who you're appointing. Is this someone that you trust? Oh, I absolutely trust them. And how do they do, like keeping up their own checkbook and their own finances? Oh, they're totally a mess. If they can't keep their own checkbook, they probably can't keep your checkbook. It's not a matter of lack of trust. It's maybe just not the right job for them. Or if they're someone that just feels a burden dealing with someone else's finances, they just don't feel like they can do it and they would just put everything into a checking account, that might not be the right job either. So I always say think through who you're appointing as the agent or the agents under your power of attorney, whether that's the appropriate job for them. Now, the other kind of power of attorney is a healthcare power of attorney. And a healthcare power of attorney is only used, you sign it now while you're healthy, but it's only used actually when you can't speak. Because as long as you can speak and communicate, if you end up in a healthcare setting, like a hospital for example, the doctor's going to ask you, can I give you this medicine? Can I transfer you to this other hospital? Can I do this procedure? What do you want me to do with this? So you're going to get asked those questions, but there might be situations where you're not able to. Certainly we have people that deal with people who suffer from dementia and things like that, and they're really never going to be able to give an answer. But we also deal with a lot of folks that have just more short-term shock. They're in an auto accident, they slip and fall on the ice and break their hip, something like that, and for the period of a couple days, a day or two, sometimes 3, their mind is kind of cloudy. But a lot of important things have to be decided in the interim in order for them to continue to get good care, because otherwise they will just be sort of stuck at the emergency room or the ICU of Meritus or Chambersburg Hospital or wherever the case may be, until someone with legal authority can direct some care. So the medical power of attorney gives that agent, whoever you appoint, it can be one person, it can be multiple people, the ability, if you can't communicate, to say, absolutely, please give my mother this care. Please give her this procedure. Please give him that medicine. Absolutely transfer him to this hospital, but I don't want him transferred to this hospital. Those types of decisions are the decisions that a medical power of attorney makes. When you regain your ability to speak and communicate cogently, then you regain that capacity. So it can be permanent, it can be temporary. So who's the right person to appoint for something like this? Again, just like with the financial power of attorney, people often reflexively just want to say, well, my oldest child. A couple things I would just have you think about. Number one, with a medical power of attorney, just like financial, but with a medical power of attorney, it might be a good idea if you have multiple people to name multiple. Just because you never know who might be at the hospital when you need someone to designate what kind of care you're going to get. So if you have multiple children, for example, or other relatives, you can appoint 1, 2, 3 of them. That's fine, that's absolutely fine, and it's whoever is there. These are generally not, in this situation, in the use of a power of attorney, these are not like the pull the plug decisions. We'll talk about that in a minute. These are really just more the kind of care. And you know, with phones today, they're usually able to communicate with other family members. So it's generally not making a decision in a vacuum, but it might be that one person is there and the other is in North Carolina on their way, but won't be here for several hours, that type of thing.
Now, does that mean, because I know that would be my fear of putting multiples, is that they all have to be there in an agreement, but that's not the case in this?
So in a power of attorney, medical or financial, you have choices. You can make them all make decisions together, generally not advisable.
Yeah.
Number one, it can put them in a conflict situation, but just from a practical standpoint. If
Yeah.
it's a financial, like getting 3 signatures on one check to pay the electric bill, it's kind of cumbersome. Same thing with medical. Generally what you want to say is each individually or together. So if they're there together and they huddle up and they make a decision, that's great. If just one of them is there, that's fine too. So,
Paul,
yes.
I was just thinking, and I don't know how by law, is there cases where you, as a spouse, you need the power of attorney? Because I, here in Maryland, and when my wife almost lost her in December 2018, I didn't know where mine was. There was a friend of the family had one, and it was decided to pull, the breathing apparatus, which we did, and she survived. But when it came time, when she actually passed away in December 2022, I was like, I had to go get a power of attorney. I had Gary as a witness came around and, we got a power of attorney set for, the order to make decisions for her going to the hospital.
Yeah.
Each state's different.
And you're absolutely correct. Each state is different. In Pennsylvania and Maryland, a spouse can make decisions, medical decisions, for their spouse. So a husband can for his wife, a wife can for her husband. So those decisions are, but not every state follows that law, which is why when we do powers of attorney, we always include the spouse. Number one, the spouse is the number one person. And then number two, sometimes there might be an issue with the name. Are you really the spouse? If you get some picky place, do you have a copy of your marriage certificate? That's unusual, but they can happen.
Or
So-
a strange, we were still kind of illegally in paperwork, but we're not together type thing, and
Yeah.
someone goes, hey, I'm a husband, but they didn't want some legal document, power of attorney say it's okay to pull the plug. We
Yeah.
go, hey, I didn't like them, so pull.
Yeah, exactly. When you do it, when you prepare a document, you designate people, you actually name them. So, as I was pointing out, you want to think through who you want to name and what sort of, skills and abilities they might have. But we always include spouses unless someone doesn't want to. I have had some clients, unfortunately my spouse has a substance abuse issue and I just don't think they would be able to make a good decision. There are times when we leave the spouse off, but typically we name the spouse and then we name others. And I often tell people, think a generation down too. You and your spouse are great, but when you're both 95, like my parents are both living and both in their mid-90s, at some point it's good to have someone who's a generation down helping out with some of those things. So, and by all means, please ask questions as we go along. This is very, very informal. So appointing someone, the medical power of attorney, let me talk about the other things that they do. So obviously designating care. But number two, and this is becoming sort of increasingly important, is the ability to direct medical records. So most people have a regular doctor they go to. Some people, especially as they get older, might have multiple doctors. They might have a doctor for their heart, a doctor for this or that. All of those individuals, all of those offices have different things for your medical record. They have tests that you've taken. If you're on any prescription drugs, they have records of that. So if you end up in the hospital, It's a great benefit, obviously, to the folks in the hospital to kind of know what's going on with your health and your regular doctor. So federal HIPAA laws prevent your doctor from just transferring those records electronically up to the hospital. It happens with just a single keystroke, probably several, but anyway, it's very easy to do, but they don't have the authority to do it unless someone designates or directs that. But only a power of attorney other than yourself is able to do that. So the power of attorney, number 2, it allows the individuals that you appoint, your agents, to be able to direct, please do send that information up to my doctor or to the hospital so that the hospital has a fuller picture of things. And then number 3, the power of attorney, the agent of the power of attorney can do something very practical, which is go to Walmart and pick up your prescription drugs if you have something like that. So if you have a regular small neighborhood pharmacy, they'll probably let almost anyone pick them up. But at larger places, oftentimes they want to see something like a power of attorney. So those are the 3 things: designating your care, directing the transfer of your medical records, and picking up your prescription drugs that your agent under a power of attorney can do. So it's a very important position. So who do you appoint? Just as with the financial power of attorney, we want to give some consideration to who's going to be right for those skills. So with the medical power of attorney, the same thing too. If you have a son or daughter that you love dearly, but they just feel crippled by having to make any decisions, they don't want to make any decisions, they're clear to you, they don't want to make decisions, then maybe they're not the right person to put into that position. If that's going to put a lot of stress on them, and they're not going to be able to make decisions. Or if they do feel pressure and stress that way, then you can appoint someone else as well, and you can explain to them, just talk together, and whatever you do is fine, that type of thing. So think through who is the right person or the right people for that position. Now, with a power of attorney, typically speaking, whether you're doing that in Maryland or Pennsylvania, you're going to have a living will or a directive care type provisions attached to them as well. In Maryland, it's a separate document, but usually you have it done at the same time. And this is the document that people use, I'll call it the pull the plug type document. And for this, I think for any thinking, believing Christian, you really need to think carefully about. Pastor Gary may guide you some in kind of what could be this way. What are the decisions and how they would play out. Our Lord suffered and died on the cross. He took away our sin, but he didn't take away pain and suffering. So we deal with pain and suffering in this world, and there's a reason for that. So just giving someone morphine at the slightest time of any bit of difficulty, and then they are basically comatose for the remainder of their life. You have to weigh whether that is morally what God is asking of you. Certainly God doesn't want us to suffer unnecessarily, but a lot of these documents can put people in a position sometimes where the plug is pulled a little too easily. So think through them, and then also some of them are age dependent. I often tell someone if it's a young couple that comes to me, making some of those decisions to say, I don't want any care, I don't want this or that, when you're age 31 and have 3 children, is a little bit different decision than if you're age 81, But the living will provisions are typically only going to be applicable when 3 things, just like the power of attorney, when 3 things all apply at the same time. First, you have a terminal condition. So old age is not a terminal condition. We will all die. Some of us will die of old age, but old age is not considered a terminal condition. So a terminal condition would be something like terminal cancer. That's an example we are all familiar with. Number 2, you're no longer receiving active treatment for it. So just giving the example of cancer, because we're familiar with people with terminal cancer, you go through chemotherapy, you go through radiation, other treatments and so forth, but at a certain point, many people say, these treatments really are not being effective, therefore, I'm no longer going to pursue any treatments. So A, a terminal condition, B, you're no longer receiving active treatment for it, and C, and this is an important C is that your death is imminent. Your life expectancy is no more than a few days. That's a guess by a physician. They can never pinpoint when that will be, but usually physicians and people in the healthcare world, are familiar with kind of the signs of someone who's naturally dying, and they would say, I don't expect this individual to live, more than just a few days. So when those 3 things apply, that's when the living will kicks in. And what a living will does is it gives you the opportunity in advance to say, if that's my situation, if that's where I am in my medical care, what do I want to happen if I go into cardiac arrest? Do I want to have CPR administered? Do I want to be put on a breathing machine? You know, it's not going to change the fact that I'm going to die of this underlying condition within a few days, but what do I want? And I have to tell, my clients, there's no right or wrong answer to that. These are things that you weigh out in your heart and what you think, and it's a different decision, perhaps, again, if you're young versus being old. I had a neighbor who was in his late 80s and had real heart problems, and he had other health ailments too, but anyway, he lived sort of behind me, and the ambulance seemed like it would be at his home, like it'd be there at least once a month, and then he'd go to the hospital, he'd be at the hospital for a couple of weeks, and then come home. And so anyway, and one of these times when he came home, he was saying, well, Paul, what do I do to get them not to, use the paddles? He was talking about the defibrillators to restart his heart. And I said, Roy, if you call the paramedics, they are going to use the paddles. The paramedics in the ambulance don't show up to your house to watch you die of a heart attack. So, all these documents are such that if you still, ask for, and calling an ambulance is asking for care, you're going to get that care. That's considered regular, ordinary care. But if you're already in a hospital setting, and your life expectancy is only a few days, the living will gives you the ability to say, look, if that's the situation, if that's the scenario, my heart stops naturally on its own, maybe you would choose to say, it's okay to just let me die at that point. You don't have to revitalize my heart to live those last couple days. Or maybe you might choose to say, it's okay to not put me on a respirator for those last few days. Again, these are things that you think through in advance. You want to think through now when you make that document as to what you think those kinds of decisions would be. Now, one of the things that's also designated on both the Maryland and Pennsylvania living will is what do you want if you're in that situation, terminal condition, only a few days of life expectancy, if you can no longer eat through your mouth, even if someone's holding a spoon to your mouth. Would you want to be put on a peg tube, which is usually in your stomach, in your abdomen, sometimes in your nose, to be given hydration, nutrition, or fed through a tube, as we often say? They give you an opportunity to say, yes, I would want to be fed through a tube, that's fine, or to say, no, I don't want to be fed through a tube. That's a decision that the living will asks you to make. And again, this is something to think through what you think is, what you think is important, what you think is morally right in those types of situations. Now, next on those documents, there's a place to say, my healthcare agent. So these would be your kids or whomever you've appointed to be your agent must follow these instructions. So what that does is it takes those kinds of end-of-life decisions away from the people that you appoint. Or you can say, my healthcare agent may talk to my doctor and make whatever decision they want. These instructions are merely for their guidance. I always tell my clients, this is very subjective. If you really think through who you're appointing and how they handle the stress of making decisions. If it's someone that is a nurse and knows how these medical things work, is very comfortable making decisions, oftentimes folks will say, these are just for their guidance, they can talk to my doctor, they can decide what they think is right. If it's someone, on the other hand, who just finds it, that would be difficult, that would haunt them long afterward to have to make a decision that's life and death decision for their mom or dad or whomever, then maybe you want to choose my healthcare agent must follow these instructions. Now you've taken that decision making for these end-of-life type issues sort of off their plate. No right or wrong answer to that. It really is subject dependent on who you pick. And again, we want to think about not just ourselves, we want to think about the people we're leaving behind and what we're asking them to do and what that does to them, what they live with afterward. And I'll say this again when we talk about wills. Talking to these people now. I have a lot of clients, particularly don't want to talk, everything is a secret until suddenly they're in a crisis situation and they say reveal the location of all these documents in their home and find out who's on it. And no, talk to the people you appoint. Tell them what you want. Tell the rest of your family, this is what I've done. This is whom I've appointed. And this is why. They might disagree with you, but it doesn't matter. At least they'll know that was your decision. That's why you made those decisions. And they won't feel so badly about the people that were chosen and not them. Why were you picked and not me? Did you take mom out to the lawyer to get that done, or what happened? If you're the one that tells your own family what planning you've done, what you've put down, who you've appointed to do what, and why, they might not like it, but they'll accept it because it's coming from you and it's your decision, as opposed to suddenly finding out that you thought you might have some of these authorities and you don't. And then you have that, why didn't mom or dad trust me? Maybe it wasn't that they didn't trust you. Maybe they didn't want you to be haunted with making a decision because they know it's difficult for you to make decisions. Maybe they didn't want you to be in charge of their finances because they know that you deal with a lot with your own finances and it's hard with your family. So they picked someone else. That's okay. They want to hear that from you. Maryland gives you the ability as well to do something called a MOLST. That is a medical ordered life-sustaining treatment. In Pennsylvania, we have them, they're called a POLST, a physician-ordered life-sustaining treatment. I want to specifically caution you about these just to think them through. I was a state legislator for a while. I actually worked on this legislation in Pennsylvania. There's a real concern I have with the way they're done. So what a MOLST or a POLST is, it's a scenario where you have, you're in a hospital setting and you have a life expectancy because of some underlying condition of a year or less. That's important. It says in the statute, a life expectancy of a year or less. Now, we all know stories of people that had a year or less of life and it's 5 years ago and they're still doing great and just got a new car. This is just a physician's guess, but oftentimes physicians, when they make these guesses, there are educated reasons why they do. So with a MOLST or a POLST, if you have less than a year of life expectancy, then what you can do is on this document, you can say, you know what, here are some things with my care that I do or do not want. And oftentimes it's the I don't want. I don't want cardiac resuscitation, I don't want to be fed through a tube, I don't want to be put on a breathing ventilator, I don't want any of these medications, whatever the case may be. Okay, that's fine, that can be appropriate. Here's the problem with the MOLST. You sign it when you have a life expectancy of less than a year. It is not infrequent that people then get treated at the hospital and they actually are now feeling better. And they go home and they carry on with life for some period of time. And hanging out there, unbeknownst to them, is this basically don't resuscitate order. Well, I was feeling terrible when I signed that. I don't feel terrible anymore. And I'm living longer than I thought. And I've forgotten about the fact that if I call the ambulance and they see this order, they're not going to do anything. If I go to the hospital and this order is still hanging around, they're just going to give me morphine and make sure I'm comfortable and not give me care. So, be careful with those. If you sign them, they are a doctor's order. They get attached to your bed. They're usually pink or orange. Make sure that when you leave the hospital, that you either discard that, shred it, tear it up, or whatever the case may be. They're meant to travel with you wherever you go. I have a lot of clients who, when they come in to see me, they'll bring out all these documents. Here's my old will, here's this other thing. I'll think, oh my gosh, there's a MOLST document. When did you sign that? Oh, 3 years ago I signed. What is that thing anyway? It's a do not resuscitate order. It means that no one's going to resuscitate you. Do you still want that? Do you have less than a year of life expectancy? No, not that I know of. Well, I was in a bad way, but now I'm doing much better. So if you sign one and that's an appropriate thing, review it with your physician and destroy it when it's no longer applicable, because that can be an order that just drags on too long. What I worked on in the legislature was making them limited to a year, and they would have to be renewed. So you have that conversation with the doctor each year, but doctors didn't like that. They wanted to be one and done. And oftentimes people, when you go to the hospital for any sort of a procedure, or if you're there on an emergency, they're like pushing these documents in front of you, sign, 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 So you're signing all this stuff, you don't know what it is. You're literally signing your life away. So just be very, very cautious of those types of documents. All right, so that's financial powers of attorney, medical powers of attorney, POLST, advanced directives, those are those things. I'm going to talk just a little bit about trusts. There are a lot of different kinds of trusts. And people often come into my office, they'll say, I think I want a trust. And I'll say, that's interesting. Why do you think you want a trust? Well, I was looking at the internet and they said that everyone should have a trust because it avoids probate and this and that. So let me talk a little bit about what a trust is. And oftentimes after I talk to a client for a while, we sort of discover together that they really probably don't want a trust. But here's what a trust is. I always tell people a trust is like a box. The trust document, it creates the box. And it's sort of like you take a permanent marker and write on the outside of the box what it's for. This is a trust to hold assets. You put things into the box. And this is who can have stuff out of the box. You know, I can have these things while I'm living, and then my kids have them after I'm gone, or whatever the case may be. Those are the rules of the trust. And then you deed things into that trust. You put your real estate account, you put your bank account, your retirement accounts, your automobiles, whatever the case may be. Okay, that's how a trust works. And then what's written on the outside, those are the rules. And you appoint someone to be the trustee. Maybe it's yourself, maybe it's somebody else. And that's the person who is sort of enacting what the trust is. There are definitely times when trusts are appropriate, but oftentimes I find people come and ask for them, and after we sort of have a longer conversation, we find that what they wanted them for is really not needed. So, first off, a few different kinds of trust. There's revocable. A revocable trust is great, it's very flexible. You put stuff in the box, you can take it out, you can change the designation of who gets what. Really flexible, does almost nothing for you. Those are also called living trusts. People say, well, they avoid probate. Okay, you know, in Maryland, probate's gonna cost you a few $100. First off, probate is not gonna cost you anything. It'll cost your heirs a few $100. Pennsylvania, the same. So avoiding probate is something in Maryland and Pennsylvania it's really not that big of a deal. If you live in some states, Florida, Nevada, Arkansas, a number of others, they have probate fees that are based on a percentage of your estate. Yeah, in those states you want to avoid probate. We'll talk about what probate is later, so don't worry about the term. But in those states you want to avoid probate, but in states like Maryland and Pennsylvania, I would say that probate is not that big of a deal, and it's not that costly of a deal. When it comes to the administration of an estate through probate, you have to keep in mind the administration of the trust is actually the same. And whether estate tax or inheritance tax is applicable in a living trust or a revocable trust, yes it is, just like under your will. So you haven't saved any taxes. All you've really done is done kind of now a double administration that someone has to deal with. So when would a revocable trust be applicable? Well, here's one case. If you own real estate in another state. If you own real estate in another state, like a vacation home, sometimes putting that into a revocable trust makes it a little easier. But that's about the only time. Irrevocable trusts are the other general kind of trust. An irrevocable trust, same thing, it's a box, only once you put those assets in the box and you've written stuff on the outside, these are the rules for the trust, you can't change it. So if you put your house in, the trustee can take the house out and sell it, but then has to take the money and put it back in the trust. So whatever you've written on the side of the box, that's in permanent marker, can't change ever, period. That's why it's irrevocable. There are some advantages to irrevocable trusts, but they're also very inflexible. So as life changes for you, things change, you can't make any changes to the trust. So it's done and done. If you're age 90, great, no problem. Probably not a whole lot of changes you need to be concerned about. If you're age 50, age 40, irrevocable trusts are really not very good tools because they're so inflexible, they don't allow you to flex with, the changes in life.
Could you do away with that irrevocable trust sometime in your life? Once
You
do
cannot.
it, It's permanent.
It's permanent. It's irrevocable. You cannot revoke it. And whatever you've put into
You
it,
could cancel the whole thing.
you can't.
Unless you die, right?
Well, I mean, the trust rules say what happens. So, there are cases where you have other kinds of trusts. So a testamentary trust is a trust that you leave in your will. So it's not a trust you create now, it's only a trust that gets created when you die. Those are also irrevocable, they're a kind of irrevocable trust. These are common, I put them in wills a lot when when it's a young couple and they have children, who are children, they're not adults yet. We'll do a trust in there, a testamentary trust that's irrevocable. So instead of everything going to those children at age 18, which is a monumentally bad time often to get money, we maybe put it in the trust to kind of cover that period between 18 and 25. The trustee can still spend money out of the trust, take care of whatever their needs might be, education, whatever the case may be, but the individual doesn't quite have their hands on the money directly. Yes, ma'am?
The question followed up with Lisa, is it irrevocable because it's filed with the court?
No, actually none of these are filed with the court. Trusts came about at a time when people wanted to keep things secret, so they're not public records. Anything filed with the court is a public record. So it's irrevocable, just meaning that it cannot be revoked, that whatever is in it, it has to follow the rules that you've already made, and that's that. Obviously, when a trust runs out of money, it just terminates. Even in an irrevocable trust, because at that point there's nothing left to have it, to have in there. a lot of people some people will create irrevocable trusts and put things into them, and the trust rules say when I die, everything just gets divided equally amongst my 3 children. Obviously, the trust terminates at that period, and whatever's left gets divided amongst those 3
So
children.
it's the attorney's responsibility to enforce that.
It's the trustee's responsibility. And with any sort of an asset, the trustee is going to have to show, the trustee is going to have to show. So when a trustee takes official action, like goes to the bank to access money in funds in a trust account, or goes to record a deed, they have to take the trust to show what authority they have to do that. So the trust itself doesn't become a public record, but it is reviewed by the county officials or the bank officials to see that the trustee has the authority. So once the assets are in the trust. Now, if you put, whatever, if you put furniture or things like that that don't have titles into a trust, I guess no one will know what the trustee does with them, because there's no public record of a transfer with those. There's no bank official that's controlling them. But usually trust assets are things that have titles: automobiles, bank accounts, investment accounts, and real estate.
So I think the question would be that if it's not filed with the court and it's not the attorney's responsibility to enforce it, who's the person that says, I'm sorry, you can't revoke this irrevocable trust? Who does that? It's your stuff.
So it's when you create a trust, you make someone the trustee. You might make a successor if that first person dies, but they're the trustee. They're the person who has the authority to do everything on the trust. So for example, if you put money into a trust and you name someone as your trustee, then that person can manage the money in accordance with the rules of the trust, what the trust document says. They might seek the advice of an attorney or an accountant or a financial advisor in doing their duty as a trustee, but the trustee is responsible. Now, if a trustee misuses those things, then any beneficiary of the trust is able to go to court and say the trustee has misused or perpetrated fraud, like if the trustee withdraws money and keeps it for themselves. There's a case where a man not long ago in Franklin, well, it's probably not an uncommon case, a man in Franklin County, in Pennsylvania, had put money into a trust for his children, for their education. And then the children were little. And as the children got older and they went to college, somehow they learned there was this trust. And the gentleman who put the money into the trust was the trustee. So it's his money. He put it into a trust for his kids. The kids were the beneficiary. He left himself as the trustee to have control. But they found out that he was actually taking money personally from it. They sued in court. And the court upheld the trust, said, no, it might have been your money. You put it in this box with these rules for these people, and now you have stolen it from those people. That's the rules. So they're very enforceable.
I hate to beat a dead horse.
That's okay.
Scenario, suppose the trustee survives the family.
Mm-hmm.
Suppose the trustee dies.
So oftentimes in a trust, you'll appoint a successor trustee. If the trustee dies, then this next person becomes a trustee. Or I like to put in trust the ability of the trustee to appoint their own successor. So if they get too old or too sick, they can appoint someone else. If they die unexpectedly, obviously. But we put those powers in. If you just end up with no trustee, the trustee died, there's no successor, there's no named individual, then actually the beneficiary is just to petition the court, and the court will appoint someone. Courts often will appoint the trust department of a bank. There's good and bad to that. Trust departments of a bank or of a trust company. I'm using stationery here from the Family Heritage Trust Company, which is a local trust company. Trust companies are great. They're professionals. They invest your money and things like that. They are absolutely the right answer in many cases. But they do charge a fee. Your son or daughter is probably not going to charge a fee. So, sometimes you choose a professional, but
Can I
sometimes you don't.
digress?
Sure.
No, you're good.
That's all right. You can put a horse, too. Even a dead horse can go into trust, I guess. So be aware.
That's why we're here.
You mentioned probate before, and you said that Maryland has, do you know what that percentage?
Maryland does not charge a percentage on probate.
How
So-
do they,
Probate, well, I'm sorry. There is a percentage, but probate fees in Maryland, same in Pennsylvania, are only going to be a few $100s. So, but with that, you have to file an inventory, you have to do all these different things. In Pennsylvania, and you have to file an inheritance tax and estate tax in Maryland. In Pennsylvania, you have to file an inheritance tax return. You have to do that with a trust too. So people often say, well, no, probate fees are a lot more than that. You know, my father died and we had to pay thousands of dollars to the lawyer and, you know, all this blah, blah, blah. That was the administration of something passing at death. Didn't matter that it happened through probate. If it happened through a trust, you have to do the same thing. So, you know, that, whether it's probate or in a trust, doesn't make that distinction. Some states, not Maryland or Pennsylvania, but some states have an actual percentage fee. Like Florida's a notorious example. They charge a percentage of everything that passes under the will itself. Probate, I guess I should say, we haven't talked about wills and probate yet, but probate is the process of taking a will to the Register of Wills office and entering it into the Register of Wills office. Or if someone dies without a will, then you know you take various documents and a petition and a copy of the death certificate to the Register of Wills office and say, okay, you know, this individual has died, and we claim to be the ones that have authority to wrap up their things, you know, to take care of stuff, sell things that have to be sold, pay off things that have to be paid. So that is probate. That's the probate process. That allows someone to have the authority to wrap everything up after someone dies. At the end of that process, you have to file a tax return with the state. And if there's tax owed, first off, if there's like income tax from the year that they passed away, that gets paid. But if there's inheritance tax or estate tax, those things have to be paid too. If there isn't any tax to be paid, sometimes there isn't, you know, you still have to file the return to verify to the state that there is no tax. Also, that process, the state wants to know that all your bills were paid before a beneficiary got something. So, you know, if you have a mortgage, if you have a credit card bill, if you have a medical bill, obviously those individuals should be paid before any heir gets any money, because that's just like while you're living, you know, you have to pay your debts.
So if you have a bank account, and on that bank account you name a beneficiary, do they still have to pay a beneficiary fee?
So named beneficiaries on things like IRAs have, you know, various retirement income accounts have named beneficiaries, insurance has named beneficiaries. You still, those things will just automatically pay a death to that individual, but there may be inheritance tax due on that, because it passes at death. Anything that passes at death.
There's no way to avoid that.
There are a few ways to avoid it, but it's not easy. And with everything, there's an equal and opposite reaction. So, you know, basically, I often tell clients that if you're willing to surrender control, you can gain, you know, some tax advantages. If you don't want to surrender control, you don't get the tax advantage. So, you know, there are things you have to sort of weigh those. Anyway, so on trust, talked about these different kinds of trusts. I'll sometimes have people that want to leave. They'll say, well, I want to leave everything to my 3 children, but one of my children has a substance abuse problem, or one of my children has special needs, and maybe they receive some government assistance. So then we'll create trusts, a special needs trust or some other kind of trust to kind of for that beneficiary, so they don't have their hands directly on the money. So if it's someone that has a handicap, for example, it won't interfere with any assistance that they might receive if they receive government assistance. Or again, if they have some sort of a substance abuse problem, that way the money can be there to help them in their life, but it won't just be spent, you know, in a way that's not healthy for them. So, different kinds of trusts do different things. And this is a real broad overview. I mean, trusts are a very complicated situation. And I say oftentimes clients get talked out of trusts, sometimes not. There are definitely times when trusts are appropriate. But it's very specific to the scenario that you have. So irrevocable trusts in some situations those are the ones you can't change. One of the advantages that they have is that they, depending on how they're drafted, they can actually take an asset and make it no longer subject to inheritance tax or estate tax. Pennsylvania has an estate tax or an inheritance tax. Maryland has an inheritance and an estate tax, but they don't apply in most situations, which we'll talk about in a minute. So, but you can use an irrevocable trust sometimes to avoid some of those taxes. Irrevocable trusts are also used in some planning that people do for long-term care facilities, nursing homes. We'll talk about that in a little bit. So those are the use of trusts. There are a lot of different ways they can be used, but in a lot of situations I find for most people they're not applicable. But for other people they are. But it really comes from a longer conversation that you would have with your attorney to ascertain whether that's appropriate for you. Now, getting down to wills. Our firm, we do a lot. We write a lot of wills, and we do a lot of estates, and we keep up with the latest statistics. And so far, the latest statistics are that our mortality has been holding steady at 100%. So everyone will need a will. I always tell people the financial power of attorney, they sometimes get used. The medical power of attorney, very seldom, but when they are used, it's an emergency situation. Our wills they'll get used one day, So a couple things I often talk to with regard to wills. First off, if it's a husband and wife, usually wills will, I leave everything to my husband, I leave everything to my wife. In Maryland, the estate tax used to be fairly low, and so what we would do is we do these special kinds of wills that would kind of, put some of the assets over to the spouse who survived and do other things. But in Maryland now, you've adjusted that. It's $5.5 million. Is an exemption, just outright exemption from any sort of estate tax. So if anyone here has more than five, I'm safely under that limit myself. If anyone's over that limit, Pastor Gary would like to talk to you afterward to help you get under that limit so you don't have to pay the estate tax. Federal estate tax, there's no federal inheritance tax, but there is a federal estate tax. That's something that is, currently it's a little over $13 million. It's double that if you're married. It was something that was about to revert back to $5 million at the end of this year, but part of the big beautiful bill that was just passed, what that did was it made it permanent. It bumped it up to $15 million or $30 million if you're married. So, so it's very seldom that I'm talking to someone where I have a situation where you have to worry too much about estate tax. It is a curiosity to me that when I have clients and I ask the question, now let me ask, if you were to sell everything you have and all of your assets, is it more than $13 million? It's always the guy in overalls and, beat up shoes and drove an old vehicle that seems to be the one that does, So, probably someone who's worked hard all their life, or has a big farm and things like that. I've had some clients, in particular here in the Hagerstown area, where they have a farm, their family's farmed it all their life. It just happens to now be right next to a highway interchange. And so you can imagine the value of that. 120 acres is a little more than when their grandfather bought it in the 20s. So, but anyway, so those are the taxes that we talked through. Maryland does charge an estate inheritance tax depending on who you're leaving things to. If you're leaving things to your children, your spouse, your siblings, your parents, no tax. But as soon as you go one generation or one step over to nieces and nephews, then you can get hit by this Maryland tax, which is 10%. So 10% is pretty high. That's where we might talk about some different strategies, maybe even using a trust to avoid it. But usually people aren't leaving things to nieces and nephews.
How about grandchildren?
Grandchildren are exempt in Maryland. So anyone in that sort of lineal line, but it does include your siblings, but grandchildren, great-grandchildren, no tax in Maryland, as long as you're under that 5.5.
If you're out of the particular umbrella and it's an entity, what's the tax for that?
An entity, so tell me what you mean by that, so I understand.
A cause or,
Oh, a charity. I should know the answer to that question. I think verified nonprofits and churches are exempt in Maryland. I'm embarrassed to say I can't remember. I'm fairly confident they are, but I'd have to check on that.
like hospice.
That would be a verified nonprofit. Anything that's a 501c3 type. And churches are automatic. Same thing under Pennsylvania. Under federal estate tax and so forth. Those are exempt entities. So. And, so anything you leave to your church, they don't have to be incorporated, they don't have to be a 501c3, I don't know what those churches, those things. A lot of times churches are not. That's okay, churches are considered automatically exempt. So very good. Leave everything that you can and want to your church, by all means. And actually, that's something we'll talk about toward the end, because I do think that that's important. So in your wills, you're sort of designating who's going to get things. So one of the things I often talk to folks about, are you interested in tithing in your wills? We talked about leaving an inheritance, but our faith is the greatest inheritance we can leave to our children or other family members. So having a tithe built into the will, if that's something you choose to do, that is something that helps to catechize them, to teach them about the faith and the importance of what was important to you. So I don't make judgments. Clients come, that's their time to do what they would like to do. But I do definitely have clients that say, I would like to leave a tithe to my church, or I would like to leave a gift to this charity or something like that in the will, and then everything else to my kids. That's fine. Now, if you have young kids and you're still having to take care of them, that's a different scenario. But if your children are grown and generally self-sufficient, that's definitely something you might want to consider. Another thing with wills that you might want to think about is the will itself. What is that going to be? That will be a public document. It will be registered and will be forever a public document. People go in and look at them. When people do a historical, they go back to look for their ancestors, they find those wills and read them. They're usually fairly dry, but a will is an opportunity also to talk about your faith. A will is an opportunity to make it a prayer. A will is an opportunity to tell your children what's important. You can put that personal language into a will, absolutely, and that will be part of your permanent record. That'll be part of what people have to kind of think through later and remember you, and also learn from what was important to you. So those are things you might want to think about. And with that, I think we're at an hour, so I better stop. We didn't talk about nursing homes. I better talk about that real quickly. If you'll just indulge me for a couple minutes.
I think there are some people here who need to hear more about wills than possibly. Do you? Your daughter said you do.
Well,
So everyone should have a will.
Everyone
In your
should have a
will,
will.
sort of like everything else, you're designating someone to be your executor. It's also called a personal representative, same thing. That's the person who's gonna wrap things up. So they're gonna sell things, they're gonna make sure your personal property is distributed, things like photo albums and furniture and stuff like that. Some of those things have sentimental value. So just as with the other things, your powers of attorney, you want to think carefully about who you put in charge. And think about the relationship they have with others. So for example, if you have children, think about the relationship that they have with their siblings. We don't want to put people in a situation where there might be conflict. If there's conflict, but generally everyone is peaceful, but it's just under the surface, maybe you think about making someone else your executor. Or maybe you talk to them, talk to the entire family. I made Alan the executor, and here's why. He lives close, he does this, he does that. But it's important to know that, it's important for your children to hear from you, or from whomever, the people in your family, to hear from you why you made the decisions that you made. So they know, first off, that they're your decisions, they weren't influenced by other people, and they weren't misrepresented. Also, I'll not infrequently have people that'll say, well, I have these 4 children, but this one I don't want to leave anything to. Okay. When I was a young attorney, I would just say, okay, and I'd write, names down, and that's what you wanted. I have a long conversation. Tell me a little bit about why that is. These are personal conversations, but they're also, I don't share them with anyone else. So, sometimes it's, I gave him money to buy a house, and I didn't give money to my other kids to buy a house. Okay, that's a perfectly logical reason. Your son who you gave money to buy a house might not remember that you gave him money, might not remember that you didn't give money to others, might not know. So it's amazing what people forget in their lives and what other siblings don't know or don't remember. So if you choose to distribute things differently amongst children in particular or grandchildren, explain why. So in that scenario, I'll say, do you mind if I put that in the will? Oh, absolutely. My son Alan, whom I love, I'm not including in this will because I assisted him long ago when he purchased this home and I didn't assist his siblings. Fine. When you're passed away and people open this up and they read it, no one is going to be hurt by that because it explains why you made the decision. Your kids might think you're wrong.
yeah, they're not left to guess.
They're not left to guess.
Yeah.
If all you know is that you didn't get included, trust me, that child will feel hurt. They'll feel like they weren't trusted. They'll feel like they were slighted. And they will feel some resentment, and that's just part of the human condition at their siblings. And that's the last thing we want. Yes?
I'll give an example of what happened with my dad. He didn't have a set up a will, or just go by whatever the state does. And the assumption, like some were thinking, the siblings going, oh, power of attorney keeps going. It's not a void once, the person passes away. Well, my dad set up where he had a bank where he had whatever in a lockbox. Well, no one could get in there because he let the bank be the executor.
Yeah.
State.
So you're absolutely right. Power of attorney ends the moment your You know, the moment you take your last breath, the power of attorney is over. So now it's whatever if you have a will, it's whatever the will says. And, you know, then the person has to take the will with the death certificate and a petition, so forth, the Register of Wills office, and they get a certificate. And that's what allows them to then continue on with those things. Yes, ma'am?
Does naming a beneficiary, does that trump the will?
Naming a beneficiary. So if you name a beneficiary on an account, then yes, that is a contract between you and the bank, you and the investment firm. And they'll do what they say, you know, whatever you've said. Doesn't matter if sometimes I'll have clients that get confused, they've forgotten that they named a beneficiary, they'll put it in their will, oh, my IRA at whatever bank, I leave to so-and-so. No, it's whatever if you already named a beneficiary and you never changed it, then that's what will happen. Which is why it's also good to review those things from time to time. So I always say at least every 5 years, take all this stuff out and review it. You know, for my clients, and you can ask your own lawyers about it, for my clients, I don't charge anything to sit down and just kind of review their stuff again and make sure it still does what they want. It's important. But wills are really an important part of it, and whatever other planning you do, like if you go to an elder care attorney and do all kinds of elaborate stuff for nursing homes and so forth, they'll still do a will, because ultimately you forget to put something in the trust or whatever the case may be, and there still has to be some disposition of it. So that's your ability to say, you know, first off, this is where my things go, this is how they get distributed, this is who's in charge, and they can get very complicated. You know, young couples with children, like, it's really important they have a will, because one of the things they could do is designate who the guardian of their children will be. Otherwise, that happens in a court of law and a judge makes the decision. Which means even if the judge would have decided on the same person that you would have appointed, it means your children have to sit in a courtroom and have a judge decide who they're going to go live with. Another thing with that, incidentally, with guardianship, I always point out to my clients, it doesn't mean that your children will go live with that individual. It just means they have the authority to designate where your children live. It might be with them, probably is, but maybe not. You know, maybe it's with an older sibling who's established and has a family of their own. Who knows? You're appointing that person to make those decisions. So, wills are really important. And as I said, they're an important document that people will read and remember and reflect upon what was important to you. They'll look at that document and they'll say, this was what was important to Mom. So it's our last opportunity to teach our family what's important to us. Which is why I don't like just, I'm excluding this person. I had one client one time who said, well, I don't want to include this person because he never treated me like a father. He never treated me like I was his dad. And I'd say, well, this is your opportunity to treat him like he's your son. Now, that's up to you. Again, people make decisions. Those are their decisions. But another thing that you can do in a will, you can give forgiveness and ask for forgiveness. You can say, to anyone I've forgiven, I ask for forgiveness. To anyone who's offended me, I give forgiveness. If that is sincere in your heart, write in your will. You can. Whoever your attorney is, they might not know that. Tell them that's what I want to have. Attorneys will do whatever you want. They're fine. They're fine doing stuff like that. They might think you're crazy, but they're fine with it. And that's a great opportunity. You're leaving this world, God willing, to the next world that is a happy reunion with all of our family. But what you leave behind here on earth, you know, this is your last opportunity to kind of make that statement of this is what's important to me and this is what I want to be left behind. So, and it's not just things.
What if you have a family business? Do you include that in your personal will, or is that a whole separate?
So businesses, when someone has a business, they own a business, you know, there's a sort of a bigger discussion about that because, you know, what are there other family members involved in the business? Is the business able to continue on without you or not? How does the business get wound down? Is it, you know, something that is an entity like a corporation or a limited liability company? So, I mean, your business is an asset like anything else, just like money in your bank or your automobile. So that's an asset too, but with any sort of a business enterprise, we always want to think about, okay, what do we do with this? Gee, oh, well, my kids work in it, or one of my children does, and the others don't. It can get complicated, but we kind of work that through. Farmers, obviously, where we live, I have a lot of clients who are farmers, and you know, you're not going to cut up a farm amongst 5 different children and have a farm anymore. So sometimes you make difficult decisions. You say, you know what, this child is the one who's actually farming the farm. I love all my kids, I want to treat everyone equally, but I just can't, because if I cut the farm up, then no one has a farm, and I've taken that livelihood away from him or her. So, fine, that's absolutely fine. I always tell clients, sit down with your family and tell them that's what you're doing. Tell them why you're doing it. They may disagree with you, they often don't, but they may disagree with you. But they'll know that was your intent, and they'll know why you've done it, and they won't feel resentment toward the one that's benefited to them. And you can find other ways to benefit your other children. If you have a big asset like that you just can't divide. And a family business can be that way too. And oftentimes in family businesses, if you have multiple children, one or two might be engaged and the others aren't. So, you have to kind of figure out what to do there. Good.
You need to go talk to him,
In other words, we're not gonna get any satisfaction tonight, because that's not possible. We need to actually go somewhere and take care of this.
Yeah, all of these things, I mean, I don't advise you go on LegalZoom and do your will of your own. Here's the number one, because I do estates too, so I've probated LegalZoom wills. If you have 3 children, I direct that everything be left between, Amy, John, and Tommy. Sounds like regular language, right? If you think back to grammar, when you were in grammar school, between is between 2.
Yes.
So what happens is Amy just got 50%, Johnny and Tommy got the other 50, they got 25% each.
Oh.
Common LegalZoom mistake. So doing all this kind of work, you don't generally do this usually most people only do this like 3 times in their life. Once when they're young and they have young kids, once when they're kind of retired or getting close to retirement, and the last time when they're more elderly. It's everything that you own and everyone you care about, it's kind of worth talking to a professional. I'm not saying that out of self-interest, it is. It's one of those times it's worth talking to a professional. My wife would say, and reminds me, like plumbing, Paul, plumbing is something that's worth talking to a professional.
Yes.
Because she had in the past dealt with a leaky kitchen sink for many years. So sometimes it's just worth it because it's part of a larger conversation you want to have, and you want to make sure all these things are right. Because again, it's everything you own, and it's everyone you care about. So, even if in the end you end up with everything goes equally amongst my children, and the oldest is the power of it, so forth, you still want to have that conversation to kind of know and feel confident that that's what you're doing. Any more questions about wills? I don't want to shortchange.
I wanted to throw something in there with everybody kind of knows what they got going on, because Friday I went to, would be your, I guess, compadre with Rob Kaufman, when we were in politics. Well, anyway, he had a senior expo up in Chambersburg on
Sure.
Friday. Well, I came across unclaimed property, the treasurer there.
Yeah.
And a lot of times if no one knows about whatever, like myself, I went and said something, there was something there with my dad or whatever.
Yeah.
So it's not, the family knows, passed along all the different ins and outs of it, so.
Every state has a state treasurer that keeps unclaimed property. So that's like bank accounts that are closed and people forgot about and they can't find the person. So you can go online, and you can do it in Maryland too, you can do it in Pennsylvania, or you can call your state delegate or state representative if you want, and they'll do it for you. And they'll check to see if there's anything under your name. And sometimes there is. Actually, when I was the state representative, there was someone who had over $100,000 of unclaimed property. That was a nice day,
So what, bringing this down, what is the ballpark figure to have a will done? And does it matter like how many things you document, or how's that?
So it obviously depends. If you go to an attorney, it depends on what they charge. You want to ask the attorney in advance. Attorneys all charge differently for doing this kind of planning. They often give discounts if it's a husband and wife who come in together. They give a discount if you do all the documents, which would be your 2 powers of attorney and your will together. Some charge more for trusts and things like that. It depends. In our office, we have a flat fee. If it's a husband and wife, they do wills and powers of attorney. We charge $990 for all of it. And that's usually at least 2 appointments, and we sit and talk as long as people want to
You
talk.
said 990?
But again, other attorneys may charge more, some may charge less. I don't really know what other attorneys charge. But that's something you can call. When you call your attorney to schedule an appointment, you can ask them in advance. Now, what do they charge for this? And they'll tell you if they have a schedule or whatever. So.
Does that change if you have a business?
No, you know, in my, again, your attorney is you have to ask that in advance. It depends on what the attorney has to do for the business. If really it's just a matter of having the conversation, helping you figure out what you want to do with the business, and then you build that into the will, like, we don't charge extra for that. But again, another attorney might. But now if you're having to do a whole lot of documents for the business itself, like your operating agreement or your bylaws and so forth, you know, then the attorney would generally charge for that. But, yeah. And you can ask up front. And no attorney's ever offended by that, incidentally. And unlike doctors never know what they charge. They really have no clue. But lawyers generally do. So they can tell you or give you a ballpark if it's something complicated. And they can say, well, that's a little complicated. And you can ask them too, is this something you do, you know, when you call and talk to their secretary or talk to them in advance? So, yes, ma'am.
If you have a will filed locally and you move to another state and you die, what happens?
So Maryland does something very unique, and I'm not aware of any other state that does it. It allows you to register your will while you're living. You don't have to, but you can take it down to the Washington County Courthouse, the Register of Wills office, and put it in and register it there. When you move to a different county or out of state, you just go to the registrar's office and ask for the will back. They ask for your driver's license, and you get the will back. And then when you move to another state, then you do what you want to do with your will there. I always tell clients, you know, your will has people always want to lock it up. Oh, I'm going to put it in a safe. That's fine if that's where you kind of keep things, to keep them together, to keep them generally safe, but no one's going to steal your will or your powers of attorney. They don't have any value to anyone other than you and your family. So wherever you keep them, keeping them together, I generally advise clients, keep your will and your powers of attorney together. Like, they leave my office with them all in a folder. I said, just keep it all together and then tell your family where they are. Don't go handing out the powers of attorney to the kids, you know, unless you want to. They're your documents. Don't hand the will to the kids. Just keep it all together. Talk to them about what's in there. People always seem to do this around Thanksgiving. I don't know what it is about that. It's because everyone's together, I guess. But tell them what's in it. Tell them where they are, and that way they know where to get it. If you keep it in a safe, like a document safe or a gun safe or something like that, that's fine, just as long as they know how to get into it. Particularly the medical power of attorney, because that's an emergency document that they might need. You know, don't put that in a safety deposit box. Don't put your financial power of attorney in a safety deposit box. It's like locking the key in. Now the agent doesn't have the document to show the bank, well, it's in the box. Well, I can't open the box, you know, unless you have the power of attorney already. So, you know, you can put your will in a safety deposit box at the bank if you want to, but the other documents don't. But usually clients just keep them all together and keep them at home someplace that's kind of safe and they're not going to get lost. And
So
then
if you're
they-
living in another state and your will's in this state, it's still a will.
Oh, absolutely,
I mean,
it's still a will.
there's no
Yeah,
problem
if
then.
you've signed a will, it's your will until you either tear it up or you sign a new one. So if you've registered your will here because you lived in Washington County, for example, and then you moved to another state, you can leave it in Washington County. It doesn't make sense to leave it there anymore, but you can, because the reason that you register in Maryland is, if you want to, is that your family will know they can go to the courthouse and get it. So
Okay.
you can leave it there if you want, but you don't live there anymore, so you might want to get the original back and keep it wherever you keep important things. But that's up to you. Yeah.
You're giving us this for free, but if we like.
You're going to get everything you paid for tonight, guaranteed.
Well, I was gonna say, we want to come in and personalize it and be kind of like, oh, we thought of something. Is there like certainty before we go and actually getting the document of the will done or whatever, you know?
So usually when I have clients who come in to do estate planning stuff, we have a first appointment, usually lasts about an hour, but it depends. Some people, they're in and out. Some people hate doing this, so like as quick as they can get it done and get out the door, they don't like to think about it. They don't like to think about their own death. It's a good Christian thing to think about, you know, to remember, honestly. But, and then generally we have a second appointment, then I usually, at least my practice is I send copies, and I always say, take a look at them, make sure I've spelled the names right. We can make any changes you want. You know, this is just where we are right now. I have some clients, we have several appointments because they want to come in and still talk through things, think through things, that's fine. Most folks though, they get the draft, then they schedule an appointment, they come in, and then at the next appointment I take time and I walk through each document one at a time before they're signed, make sure people understand every bit. We use a lot of legal terms in those documents. There's a reason why we do, because those legal terms mean something specific, and if I had to write them out, it would be a whole paragraph like perturbies my lineal issue is a very simple way to write something that would otherwise take a whole paragraph. So I would just walk through those, and then people, can ask their questions and make sure that it's what they want, and then sign it. And when we sign wills in our office, and most lawyers will do this, you'll have 2 witnesses and a notary. So you have 3 people that are there to witness when you sign them. Makes it much easier when your family goes to probate that will. Same thing with trusts. With the trust document, we'll always have 2 witnesses and a notary, so they're notarized in the end, so they can be admitted into court if ever need be.
So do you have other things on your paper you're going through, or is this supposed to be where we ask questions?
You can ask questions anywhere you want. I know, Teresa, some people always like to ask about nursing home things, and I thought I would
Yes.
touch on that because I know people have questions about it.
Yes,
So,
okay.
maybe
That's on my list of questions.
Okay, good.
It's
So
one of the things.
I'll move on to that, and then just any questions you have.
Okay.
So nursing homes. Nursing homes are very expensive. We all know that. And we all certainly know people that are in nursing homes for long periods of time, and they use up all the resources they have. Everything has to be sold and so forth. I encourage people to have a broad thought about this and think through what is right to you. And as I said before, I don't cast any judgment. What I'm about to say is not a judgmental thing. It's more a matter as a lawyer. I think it's important for you to understand how things work, and you probably already do, but understand it fully so that you can make the best educated decision. So long-term care, that is care in a nursing home, long-term care facility or a full-skilled nursing facility, it's very expensive. In this area, generally around 10 grand a month. It doesn't take long to really blow through a lot of cash. Now, that is 24-hour, full-skilled nursing, hospital-like setting type care. Under the law says that's your responsibility. Medicare, which is the federal program that is for everyone who's older, does not cover that beyond 90 days. Medicare will cover up to 90 days if you're in like rehab. So if you fall and break your hip, and you end up in the nursing home for rehab, Medicare is going to cover that for up to 90 days. But beyond that, if you just need to go live in a nursing home because you can't live at home anymore, Medicare is not going to cover that at all. Some people have long-term care insurance. It can be great. It's very costly, but that might pay for all or some of your nursing home needs. Otherwise, the thing is you need to pay for that out of your own funds. But as part of the safety net, as part of what is called welfare, Medicaid, which is Medicaid is a program to cover medical expenses for the poor, will cover the cost of your nursing home care for all of your life if you have depleted the rest of your resources. So that's the if. If you've depleted the rest of your resources, Medicaid will cover the cost of your nursing home for the rest of your life. So no one will ever be out on the street unable to care for themselves in their old age. They will always have that. It is part of the safety net that we all enjoy. So that's Medicaid. There are things that you can do to plan to make yourself destitute so that you qualify for Medicaid. I meant to say that exactly as I did. There are things you can do to make yourself destitute so that you qualify for Medicaid. I have some clients who say, absolutely, that's what I want to do because I want to pass things on to my family. I have a house, I want to pass it on to my children, and that's what I want to do. So you can put that in a revocable trust and do different things, and therefore, after a certain period of time, 5 years as a look back, that will no longer be visible to the state of Maryland or the state of Pennsylvania when they look to see whether you qualify for Medicaid. Then Medicaid will cover your costs, and your children will have your home after you've passed away. That's fine. That is legal to do if you do it under the right way. It is not what Medicaid is designed to do. Medicaid is designed to take care of people who are poor. It's not designed for people to shift their assets over to special shelters so they be given to other people later and the taxpayers pick up the tab. The reason I put it that way is I just want to be honest with you with what Medicaid or elder law planning is. It's not immoral, it's not unethical, but it is something that you do have to think about for yourself, and I want clients to be fully cognizant of what that is. I don't make judgments. I have clients who want to do that, that's fine. I don't have a moral, I don't have a moral repulsion to it. I like to read murder mysteries. I can think of some ways that you could kill your neighbor if you wanted. I'm not going to share those with you because that would be something that I would consider repugnant. Medicaid planning is not repugnant in that way. So when I have clients who come to me and they say they want to do that, right on. Let's talk about what you can do because it is absolutely legal. We're not doing anything that's illegal. It is not what Medicaid is designed to do. It's not how it's designed to work. But the government leaves the loopholes and you can take advantage of the loopholes. So I have some clients who like to do it. Then I have some clients, after we kind of talk about what that is, they say, I don't want to do that. And that's fine too. So I just bring it up to say, you know, too often I think you can go to seminars and you hear all about this and no one will ever actually mention what Medicaid is and what it's meant to do, how it's meant to cover people, and how it's actually not made to be a device for you to pass valuable things onto your assets so the taxpayers can pay for your care. But it is legal. So I'm just being straight out honest so that you can be honest with yourself as you reflect to what you might want to do. Now, what are those loopholes that are legal that you can take advantage of? So anything that you give away, if you give it away today, 5 years go by, 5 years in one day, when you fill out that Medicaid application, they don't see that's beyond their sight. They only see back 5 years. You could have given away Mar-a-Lago, you could have given away a Rolls Royce, it doesn't matter. Whatever you gave away, if it was 5 years and one day ago, it will not create any disqualification when it comes to Medicaid. So then if you need to go into a long-term care facility, or if you're already in one, there's no disqualification. If, however, you've given something away for value, and it's not been sold, it's not like you sold a used car and got value for it, you've given it away as a gift, and somewhere in that 5 years you do need long-term care, and you do run out of money, you might have created a period of disqualification that someone has to come up with the money to cover in the interim. Now, I want to say something that people, it's sort of a misnomer. You often hear people say, I often hear clients say, well, I don't want the nursing home to get my house. The nursing home's never going to take your house. The nursing home doesn't want your house. Nursing homes don't sell houses. They don't buy houses. They don't take houses. Nursing homes take money from you to give you the care that you have. And when you run out of money, they give you a Medicaid application, and then they take money from the state. That's how they work. They will not require you to sell your house. When you fill out a Medicaid application, Medicaid doesn't require you to sell your house while you're living either. Even if no one lives in your house anymore, they don't require you to sell your car, and you can keep a certain amount of money in the bank. Currently it's $2,500 if you're by yourself. Very specific rules, and they change a little bit every year, so you want to, when you talk to your attorney, you sort of ask about that if that's the kind of planning that you want to do. So, but what happens is after you pass away, then the state of Maryland or the state of Pennsylvania knocks on the door of your state and says, oh, by the way, you know, your loved one passed away, we're very sorry. During their lifetime, we paid $80,000 for their care, so we have a claim for $80,000. In Maryland, Maryland does something kind of also unusual, is they will actually put a lien against your home while you're living to make sure that they get paid after you've passed away. So all you're doing is the estate is reimbursing the state for what the state paid out for your care and welfare payments during your lifetime. The state says, well, we only have these payments for people that are poor, so if you died with a valuable asset, you know, justly, we should be reimbursed for what we paid. If you don't have any assets, then fine. The state pays for it. So through a gifting schematic, what you can do is you can set up some gifts, wait the 5 years, and then those gifts are beyond, you know, that period of disqualification. Or you can make gifts into certain kinds of irrevocable trusts, they're called Medicaid trusts, that basically sort of set that money aside, and if you still need the care within 5 years, then the money's still available there to cover the care, but if you make it past that 5th year, then it's not going to be part of what you need. There are things you can do with your real estate, and this gets really complicated. And we do some of this work in our office. We don't do, especially a lot of what we call the crisis, like someone's going to the nursing home within a few days or a month. There are elder law attorneys who do. Michael Day is one in Hagerstown. Jared Childers is one in Pennsylvania, in Franklin County. They're very good at doing that kind of planning. It's expensive. It's thousands of dollars. But that's the kind of planning that they do to preserve assets and basically make it to where you qualify for Medicaid, even if you're inside of that 5-year pocket. if I have clients that have large, sometimes I have clients, it's not so much that they're trying to like gift things away because of Medicaid, they just want to start a gifting schematic, like they've got different pieces of property, they've got hunting ground, they've got things like this that they want to give to other family members while they're living. Then we talk through what's a good way to kind of do a gifting program that allows them to do that. There is federal gift tax, but again, that's a high threshold. You can give $5.5 million over your lifetime and not have to pay any gift tax, so most of us are safely under that. So I'm not going to talk, I'll answer any questions I can, but I'm not going to talk any more about nursing homes and nursing home expenses other than kind of just open the bucket that there are planning things that you can do, but they are very specific to your particular situation. So if you seek the advice of an attorney, the attorney will help kind of guide you through what those opportunities might be if you want to take advantage of them. But one thing I also caution, if your planning is that if I need long-term care in a nursing home, I want Medicaid to pay for it, Medicaid dependent people are not going to be accepted at every nursing home. So if you want to go to Menahaven, which is a first-class nursing home, you're not going to go there as a Medicaid dependent. They only have a few slots, and trust me, they're always filled. So that's something, when I deal with estates after people pass away, sometimes people, it's interesting to me that sometimes you'd think that family members are happy for all the money that's left to them. I can't tell you how often I meet with adult children and they'll say, I never knew mom and dad had that money. I really wish they'd taken a trip. I really wish they were in a long-term care facility that was closer to me so I could visit them more. So anytime you limit your options by just being a Medicaid patient, you might have to be in a nursing home that's in Frederick County, that's further away from the people that you love that otherwise would visit you. Something to keep in mind. There's, as I said earlier, there's no right answer, there's no formula that everyone can use and take out of this and go home and plug your stuff in. It's complicated, you want to weigh a lot of different things because for everything that you gain, you give something up and you have to figure out what's right and what's best for you and your family. With that, any questions? I know we've gone longer than an hour, but I'll stay as long as people would like, but I'm happy to answer any
Well, I have
questions.
2 other questions, but I don't want to hold people up, so I can talk to you after they leave if you want.
Sure.
One might apply to some other folks here. If a person lives in Pennsylvania
Mhm.
and owns a rental property in Maryland, or vice versa, how does that work out, like as far as if the people die and they still owe money on that? Or like as far as inheritance taxes and estate taxes and all the things that you were talking about, how's that work when you live in different states for property that you own?
Mhm. Yeah, not uncommon, especially where we live. I mean, we're 30
Yeah.
minutes in 4 states, so people oftentimes own things in other states. So if you pass away, and someone's taking your will to whatever county, say it's Washington County, Maryland, but you own something in Franklin County or you own something down in Martinsburg, all that happens is after you've opened the estate here, then the attorney is going to register that estate in that other county to get the authority to dispose of the property there. Obviously, when you die, if there's any debt, if there's a mortgage on property, it has to be paid. That all debt has to be paid first, so those will be taken care of. But that's how that person, your executor, would then have authority to whatever, sell or give or whatever's going to happen in the property in another state. If you have property, it's in a business again, then the business is going to dictate kind of what happens with that. People use trusts sometimes. Like I have a lot of Pennsylvania clients that have beach houses in Ocean City. They'll use a trust sometimes to put the beach house in. It's not a tax saving. What it does, it just takes out the whole Maryland probate thing, so it's a little bit less hassle that their family has to go through when they want to go sell that beach house. But that's, again, something that you can do to,
Can anybody, okay, let me tell you.
yeah.
I knew a lady that died in Hagerstown,
Mhm.
and my uncle was made the personal representative.
Sure.
But he lived in Virginia, and he could not settle that estate as a Virginia resident. He had to he had owned property up in Camp Hill, Pennsylvania, and that's where he had to spend a certain amount of his time in order to consider himself a resident so he could settle the estate in Maryland. Are there still rules like that?
There are not rules like that. You can make
Okay.
anyone your
I
executor.
was back in about the
Yeah,
60s.
You can, okay. That's before the time I was practicing law, so I can't speak to that. But yeah, you can name anyone in any state to be your executor. Obviously, there's a practical element to that. Now with like internet banking, it's quite easy for people to do things even from long distances. But when it comes to like just selling a house and those things, if you're closer, it's more practical. But that doesn't necessarily mean that that's the right person. you know, sometimes people choose a family member that's far away. If they're in another country, it gets kind of tricky, because then, like, having things signed and notarized get really hard. But if they're somewhere else in the US, I deal with executors all over the US who are executors in Washington County, or executors in Franklin County, no problem.
Well, my next question was very specific. My mother just went to get her real ID,
Mhm.
and on her one birth certificate, her name is spelled differently than she has spelled it all of her life. I said, who told you to spell it that way? My mother, when I was starting to learn to write my name. So her license and everything else is spelled this way, and her birth certificate, it went through with the real ID. I'm pretty sure they didn't even look at it that close, you know, so she's gonna get a real ID, but it's one letter. She spelled her name D-E-L, and they spelled D-O-L on the one birth certificate that's handwritten. Is that gonna create a problem someday?
No,
That's good enough.
it is not uncommon.
She wondered.
It is not uncommon to find it, get a, you know, have a death certificate and later have a birth certificate that don't align with names, especially middle names. People, for whatever reason, you know, when they're there at the hospital, they give their child's middle name and then they either forget or they change their mind. And for the rest, my grandmother was that way. The rest of her life, she had, you know, she used a middle name that was actually not the name on her birth certificate. She found out in her 80s, and she was mad, incidentally. But that's not going to create a problem when you probate a will. What you do is on the petition that you actually give to the register of wills, it gives the name of the individual. But a lot of people would be like, my middle name is Thomas. My will says Paul T. Schemel. It'll say Paul Schemel, Paul T. Schemel, Paul Thomas Schemel. These are AKA, also known as. Someone who is, has a married name. Sometimes we'll put the maiden name, the married name different ways, because, you know, like my wife uses her maiden name. Her families always use, the women always use their maiden name as their middle name after they're married. Other families don't do that. So, you know, the petition is a place to put all those names, and that's fine. As long as we can identify it. You know, the individual on the death certificate is the same one that had this house, and that's easy to do.
The other thing I was thinking, and it probably doesn't apply unless, you know anybody, but being a veteran, I was looking at going to Jack, but then it's Tommy most of the time, you're just like, do they have that open to that expense matter that comes like someone you yourself, like when you get there, Tommy, it would cost way less than what the Jack. That's the thing I was looking at.
Yeah, so if you're a veteran, there are a lot of veteran benefits that you have. And, you know, by all means, you should take advantage of those, even if they're a little, not always, you know, as convenient. So a JAG officer preparing some of these documents would be absolutely good. If you're, I think you said you're in Pennsylvania, you go up to 48 County Gap, you get it done. Same thing, with veterans, you talk to a veteran service officer, there are lots of benefits that are available to veterans. And by all means, I mean, you've served, and those are things that have been granted to veterans for a very specific reason. So a lot of benefits that you make sure you know of and you can take advantage of. Yeah.
So you said we should have our documents reviewed, maybe every 5 years, that's your suggestion. But power of attorney, advance directive, those documents, they do not expire, do they?
No. So I recommend that people take their documents out and at least look at them at home to make sure that, you know, oh goodness, the person I named as the executor, they passed away, you know, things like that. So obvious things, or sometimes you want to do something different. Like I said, there's generally 3 times in people's life when they do well. You know, between getting to a point where you're close to retirement, and your children are adults, and you know, being, you know, in older age, sometimes your kids are all retired and don't need anything at that point. People think about their grandkids, you know, and again, like thinking about tithing to your church, thinking about giving to charities, the things, especially at that age, that you can do because there aren't people that are financially dependent on you anymore. So it's just good. It's a good practice to review those every 5 years. If you want to go in to see your attorney to review them, that's great if you have questions, but at least you look through them. But when you sign a power of attorney and a will, it's good until you until you either shred it up or you sign the next one. Yep. So one of the things you can do too that's important.
We knew I had to be there.
Sure, is if you have documents like that, when they're no longer, if you got a new will done, for heaven's sakes, shred up your old one, because You know, I've definitely had estates where we're like halfway through and then we find out, oh my goodness, there's actually a newer well. Cleaning out the house, we found a newer well, and it does something totally different, and that can be problematic. Another thing too, I should have touched on this earlier, it's really important. What you want to happen to your remains when you pass away, if you want to be buried in this cemetery and so forth. You know, I definitely have people that have gone to a church all their life, but maybe their children have moved away, their children are not part of the church, don't realize that don't even think about it, and you pass away, they have you cremated, they throw you in the park. I'm not kidding. And then the rest of the congregation finds out, oh no, you know, they passed away, you know, we didn't have an opportunity to have a funeral, all these things are important. So those are things, you can put them in your will. It's more important just to tell your children or your family what your desires and wishes are with that regard. That's really important. This is what I want to happen when I pass away. This is where I want my funeral. This is who I want officiating. This is where I want to be buried. They need to know that. In your will, we can put it in your will. I don't usually advise that because people often don't look at the will until after the funeral. And I've definitely had wills where we've opened them up and realized Mom got buried in the wrong place.
She didn't want to be cremated.
Yeah. So those are things. I mean, I cannot tell them the importance of talking to your family about all these different things. And you know, they might say, "Oh, we need to talk about this. I just want you to know. I want you to hear these things from me. It's because I love you. You know, I don't want any future problems after I'm gone. But these are the things that are important to me, and I want these things, you know, passed on to you. And this is why I've done them. You know."
I'll take that a step further. We just went through a situation with my stepfather. He was very secretive about everything. Fine, his business dealings, everything. It was a disservice to the family trying to sort that mess out when it was over.
Yeah.
So that clutching everything in, it does no good when you're gone, because it really made it tough for us to try to figure out what he would have wanted done.
Yeah.
You know, so.
You know, German stock Mennonites are the worst about keeping everything. That's my business, you know.
That's us.
Whereas Italians are telling you every day what their new, what they want to do.
Well, I'm sure his estate was settled in a way that
Yeah.
he probably wouldn't have agreed
Yeah.
with. I mean, we tried to follow everything to the letter of the will,
Yeah.
but there was still some things, the way the will was written is not the way the register of the wills interpreted it.
Yeah.
So there was some monies went places that I'm sure my stepdad hadn't thought that way,
Yeah.
but he didn't make it known, so.
Yeah. Having those conversations is so important. Yeah, you're right. It's naturally, we don't want to burden our kids with it, and we want to be able to make different decisions, you know, and it's awkward to say, well, I've changed my mind on some things, but those are important, and they're important because people your kids who hear those things from you are less likely to have conflicts with their siblings after you're gone about what you've decided, because they've heard that from you. Thank you.
Thank you.
Paul, thank you so much for coming. It was a very informative evening for sure.
Yeah, my privilege, thank you.
And I'm sure that we'll have some more parts of this journey to go through, but I'm glad that you came here to help us with the end of life, and we can be here to talk about the beginning of life in Christ, and we can celebrate that together. Let's just close our time out here with a word of prayer here then. Father, I thank you in the name of Jesus, Lord, that through you, Father, we have life, we have eternal life. And Lord, I just thank you for Paul coming here tonight. I pray that you would bless him, that you would bless his family, and that, Lord, that as we make decisions, Lord, about the things that you have blessed us with, I pray that you would give us wisdom, Lord, to know what to do with them and where to put this and where to take that, and that, Lord, that we would honor you in all things. Pray that you bless us this evening as we go from here, and that you protect us as we go, and that you help us to continue to be a witness, Lord, for you. In Jesus' name we pray. Amen. Lord,